Welcome back to the Constitutional Clarion. This is just a quick video today about an issue that the media asked me about this afternoon, and that is whether a judge of the Tasmanian Supreme Court, Justice Geason, who was today convicted of a criminal offence, can be removed from office if he does not resign. Ordinarily, judges of superior courts have tenure until a compulsory retirement age. This is intended to protect their independence from government, so the government cannot pressure or sack them if it doesn't like their judgments. But there does need to be an ability to remove judges if they become incapacitated or if they engage in misbehaviour. This is commonly done by requiring each House of Parliament to pass a resolution requesting the Governor-General, or the Governor, as the case may be, to remove the judge. This means that it's not within the exclusive control of the executive government. Both houses must be convinced of the need for removal, which of course will commonly include a house that is not controlled by the government. For example, at the Commonwealth level, Section 72 of the Commonwealth Constitution says that justices of the High Court and other federal courts shall not be removed except by the Governor-General in Council on an address from both houses of the Parliament in the same session praying for such removal on the ground of proved misbehaviour or incapacity. This raises unresolved issues about what amounts to misbehaviour. How is it proved and by whom? Is it the houses that have to determine whether the misbehaviour is proved, or is it a court or some other body, like an anti-corruption commission, for example? Does the judge have a right to be heard by each house? Can he or she be questioned by members of each house? These questions were raised in relation to allegations that were made against the former High Court Justice Lionel Murphy. His conviction on perverting the course of justice was later overturned on appeal, and he was then later acquitted of the same charge. While further allegations of misbehaviour were made against Lionel Murphy, he died before the matter was ever resolved. Hence, there's an absence of relevant precedents about how to deal with the removal of a judge for misbehaviour. In Tasmania, it's even more difficult. This is because Tasmania does not have an equivalent provision to Section 72 of the Commonwealth Constitution. Instead, there is the Supreme Court Judges Independence Act of, get this, 1857. So very early legislation for Australia. And it says this: it shall not be lawful for the Governor, either with or without the advice of the Executive Council, to suspend or for the Governor to amoval any judge of the Supreme Court unless upon the address of both Houses of Parliament. And yes, I did say amoval, which is an old-fashioned technical term for the process of removing a judge. The Tasmanian government proposed in December last year to rely on that provision to support the suspension of Justice Geason. Counsel for Justice Geason, however, pointed out that this section operates in the negative. It says that it's not lawful to suspend or remove a judge unless upon an address of both Houses of Parliament, but it doesn't actually give the positive authority for that suspension or removal. Counsel argued that to find that authority, you had to go back further into British legislation, the Colonial Leave of Absence Act of 1782, which was indeed before the First Fleet came to Australia. And it said that if a person holding an office by patent in a colony shall misbehave in that office, it is lawful for the Governor and Council to amoval such a person from such office. This provision was relied upon to amoval Justice Willis of the New South Wales Supreme Court in 1843. Justice Willis then appealed to the Privy Council on the ground that this British Act, he said, did not apply to judicial officers. He also argued that his amoval was invalid because he was not given the opportunity to be heard in his own defence. The Privy Council, in the case of Willis against Sir George Gibs of 1846, concluded that the Colonial Leave of Absence Act did indeed apply to judicial officers. The authority it relied upon here was, quite remarkably, the amoval of the same Justice Willis from judicial office in Canada in 1829. The Privy Council confirmed that this act also applied in New South Wales. However, the Privy Council still reversed the amoval of Justice Willis on the ground that he ought to have been given some opportunity to be heard in his defence and that this had not occurred. Not long afterwards, in 1849, a judge of the Supreme Court of Van Diemen's Land, now called Tasmania, was amoved by the Governor for misbehaviour under the very same provision. It was upheld by the Privy Council in the case of Montague and the Lieutenant Governor of Van Diemen's Land from 1849. So we know that this substantive law does apply in Tasmania, or at least did apply in Tasmania, and that it supported the amoval of judges. And it seems that this law has not since been repealed as part of Tasmania's statute law. But getting back to the current case of Justice Geason, his counsel argued that the Colonial Leave of Absence Act only dealt with amoval, not suspension. Hence, any attempt to suspend him pending his trial on criminal offences would, they said, be challenged. Now, at that point, the Tasmanian government backed down and instead decided to enact substantive legislation setting up a body to deal with complaints against judges and a process for suspension and removal, which is obviously a sensible thing to do. Most other jurisdictions have already done it. However, that legislation, which is quite complex, has not yet passed the Tasmanian Parliament. So where does that leave matters? It would appear that the 1782 Act still applies in Tasmania and permits judges to be amoved by the Governor on the ground of misbehaviour. This is then qualified by that 1857 Tasmanian Act, which says that such a amoval of a Supreme Court judge by the Governor would not be lawful unless it's done upon the address of both Houses of Parliament. So the process is very similar to that set out in the Commonwealth Constitution. There needs to be an address by each House of Parliament to the Governor. And an address here is really just a resolution passed by the House petitioning the Governor to act. The ground for amoval must be, in this case, misbehaviour. The requirement, however, in the Commonwealth Constitution that that misbehaviour be proved is missing from the Tasmanian legislation. A further constitutional issue is whether the Commonwealth Constitution imposes any constitutional constraints upon how a state removes a judge. While the doctrine of separation of powers does not formally apply at the state level, the High Court has concluded that as state courts are receptacles for the exercise of federal jurisdiction under Chapter 3 of the Commonwealth Constitution, those courts must maintain their decisional independence. If a state were to act in a way that undermined judicial independence and impartiality, it might well breach Commonwealth constitutional requirements. However, the High Court held in the case of Northern Australian Aboriginal Legal Aid Service, Inc. and Bradley in 2004 that there is no single ideal model of judicial independence and there is room for legislative choice in this area, including different constitutional arrangements. As the Tasmanian law is very similar to the process set out in Section 72 of the Commonwealth Constitution, it's unlikely that there would be a problem with its validity, although any future law would need to take into account the constitutional imperative to maintain judicial independence. There remains, however, some uncertainty about the application of these removal procedures. First, is there misbehaviour? It would seem arguable that a criminal conviction for assault would constitute misbehaviour, even though it does not directly concern the judicial functions of the judge. Second, there are issues of process. We know from the Willis case that any attempt at removal must involve natural justice in letting the judge have a say and to defend himself or herself. How this is done, whether it's by the tabling of a written statement in each house or by the judge personally making a statement at the bar of each house, and whether questioning of the judge by members of parliament in each house is permitted, remains a matter for a resolution of the House. Finally, there's the problem of appeals. If Justice Geason appealed his conviction, should Parliament wait until the appeal process was completed before acting? Remembering that Justice Lionel Murphy's conviction was overturned on appeal and he was later acquitted, it would probably be wise in the circumstances to wait, although of course there is a risk of damage to the reputation of a court in the meantime. I hope you found this interesting and informative, and as always, I look forward to seeing you next time on the Constitutional Clarion. Goodbye.